100 WPM without any stop. Be ready and start. The conflict between public health and individual liberty is incessant, yet few legal scholars could have predicted the stand of the judiciary to halt the Puri Rath Yatra and very possibly the spread of the coronavirus. On June 22, a bench reversed its earlier decision of prohibiting the yatra in Odisha. Earlier, the court had extolled the necessity of curtailing mass gatherings notwithstanding its religious significance. Later, without any cogent legal reasoning, the Supreme Court chose to permit the festivity with certain restrictions. Not only is such reversal legally arbitrary, but the court's order creates worrying precedents for the right jurisprudence in the larger socio-political backdrop of contemporary India. The first judicial order implicitly restated a well-established legal principle that a right to freely profess one's religion is subject to public health. This restriction is recognized within Article 25, which confirms the right to practice one's religion. Such restrictions are necessary to bolster different rights of others. Case in point, the enforcement of the right of religious freedom of some could endanger the right to life and health of others, which is simultaneously guaranteed by Article 21. It is the judiciary's duty to balance such competing interests and establish a discernible standard of religious freedom. Through a catena of judgments, the position of the law is that religious freedom cannot infringe the various rights of others. An obvious question then arises that should it not be impermissible for one religion to indulge in mass gatherings which could increase the spread of a dangerous virus and consequently endanger the life of others? Further, in seeking to manage, though not ostensibly micromanage, the Rath Yatra by imposing a multiple-day curfew in Puri and curtailing transport, the court has impermissibly distributed the burden of religious activities indiscriminately amongst both disciples of Lord Jagannath and non-adherents alike. By endangering the lives and health of the general populace, the court has displayed a unilateral commitment to religious rights of the Hindu majority at the cost of not just the right to life but also the right to movement of others. Notwithstanding the impact of the order, the court has preemptorily apportioned guilt of any possible outbreak by noting that the organizing committee of the Puri temple administration would be responsible for adhering to the court's guidelines. The difficulty in applying this decision to future adjudication is exaggerated as the Supreme Court failed to either identify the rights it was engaging with or to lay down perceptible standards to resolve future rights conflicts. Due to this ambiguity, there is a possibility that those who have greater access to judicial counsel and fora would be able to unilaterally enforce their rights at the cost of the weak and downtrodden. Furthermore, although the lack of detailed reasons is condonable given the paucity of time and the limitations of hearings over video conferencing, the sudden reversal of its order calls into question the finality of orders of the final court of this country. The Supreme Court's decisions are unappealable. Once determined, a case cannot be reopened save to correct patent errors or account for changed circumstances. In our opinion, neither of these conditions existed in the present case. The severity of the pandemic had not changed, nor had the competency of the authorities to control it. Instead, what seems to have changed over the course of 4 days is the neutral stance of the state of Odisha, which chose to support the Yatra, but changing conclusions on the basis of changed stances of parties in adversarial litigation is extremely myopic. It augments delay and undermines the public trust in the judiciary. Additionally, it incentivizes dominant parties to bench hunt and reagitate lost battles. The Indian Supreme Court has come under recent criticism for its perceived favoritism towards the Hindu religious majority in general and the ruling party specifically. This decision is unfortunately not the only time when the apex court's impartiality was called upon question. However, all is not gloom. Although the High Court definitively distinguished applicability of the Puri Rath Yatra judgment to a demand for allowing a similar yatra in Gujarat by highlighting